Our first order of business is to address 24 pre-trial motions submitted by the parties. The deadline for the parties to file pre-trial motions was August 5th. Answers to the motions from the other party were due August 15th. The rules that were written by the senators and passed 25-3 require any motion that could result in dismissal of an article of impeachment to be voted on by the members of the jury, the senators. There are 16 such motions that could result in dismissal of articles of impeachment. Unlike regular session, where members speak and debate on the floor, the members passed rules which do not allow questions, discussions, or debate from the floor. As you know, in a regular trial, a jury does not make public comments during a trial, and neither will this jury. After the members of the court vote on the 16 dispositive motions, I will rule on the remaining 8 motions, which the rules require the presiding officer to do. It is possible that through certain votes by members of the court, some or all of impeachment could be dismissed. If the articles are dismissed, the court will enter a finding that they are dismissed with prejudice, thereby satisfying Article 15, Section 5 of the Constitution, reinstating Attorney General to office. However, if any articles remain after votes on pretrial motions, the rules require we move forward with a trial. We will now take up pretrial motions under the rules. It takes a majority of members present, that is 16 voting members, who are eligible to serve as jurors to grant a motion for dismissal. Per the rules, all motions and answers are required to be filed prior to the trial, and the arguments of the counsel for both sides are contained therein. Members, you have read the pretrial motions and the answers to the motions. For each motion, you will indicate on your voting form, yea or nay. A yea vote is to grant the motion, a nay vote is to deny the motion. The bailiff, as you know, will collect your votes. The clerk will then announce them, each vote and the tally. And after she has tallied the votes, I am required by the rules to confirm your vote is accurate, so I will call each of you one by your name, and you will rise in place and state how you voted, yea or nay. As previously mentioned, a motion is considered granted if it receives yea votes from a majority of the members present, which is 16, and who are eligible to serve as jurors. Members, we will now take up motion 22, submitted by Respondent Attorney General Paxton. The motion is entitled, No Evidence Motion for Summary Judgment on All Articles of Impeachment. A yea vote is to grant the motion. A nay vote is to deny the motion. Please mark your vote on the voting form. Bailiff, will you collect the votes and bring them to the clerk? Are all of the votes collected, Bailiff? Thank you, Austin. Thank you, Matt. The clerk, Ms. Spa is our Secretary of the Senate. The clerk will now poll the votes at random and read them into the record.
Flores, no. Eckhart, no. Colcourse, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. King, nay. Sparks, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, nay. La Mantilla, nay. Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, nay. Campbell, yay. Nichols, nay. Blanco, nay. Twen 24 nays, 6 yeas.
I will now confirm the vote of the jury in alphabetical order. Senator Alvarado, you vote. Senator Betancourt.
Yay.
Senator Birdwell.
Nay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart.
Yay.
Senator Flores. Senator Gutierrez.
Yay.
Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman.
Yay.
Senator Hughes. Senator Johnson. Senator King.
Nay.
Senator Colcourse. Senator La Mantilla. Senator Menendez.
Nay.
Senator Middleton. Senator Miles. Senator Nichols. Senator Parker.
Yay.
Senator Perry. Senator Schwartner.
Yay.
Senator Springer,
Yay.
Senator Sparks, Senator West,
Yay.
Senator Whitmire, Senator Zaffarini. 24 nays, 6 yeas. The tally is confirmed. The motion is denied. Members, we are now taking up motion 9, submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Exclude Evidence of Any Alleged Conduct That Occurred Prior to January 2023. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your voting form. Bailiffs, please pick up the votes. Are all votes collected? Thank you, Bailiff. Clerk will pull the votes at random.
Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yea. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, yea. Alvarado, nay. Campbell, yea. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Perry, yea. Colkhorst, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Eight yeas, 22 nays.
I'll confirm the votes. Senator Alvarado? Senator Betancourt?
Yay.
Senator Birdwell?
Yay.
Senator Blanco? Senator Campbell?
Yay.
Senator Creighton?
Yay.
Senator Eckhart?
Yay.
Senator Flores?
Yay.
Senator Gutierrez? Senator Hall?
Yay.
Senator Hancock? Senator Hinojosa?
Yay.
Senator Huffman? Senator Hughes? Senator Johnson? Senator King?
Yay.
Senator Colcourse? Senator LaMantia?
Nay.
Senator Menendez?
Yay.
Senator Middleton? Senator Miles? Senator Nichols? Senator Parker?
Yay.
Senator Perry?
Yay.
Senator Swertner?
Yay.
Senator Sparks? Senator Springer?
Yay.
Senator West?
Yay.
Senator Whitmire? Senator Zaffarini? Being 22 nays and 8 yeas, the motion is denied. Members, we are now taking up motion 8, submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Articles of Impeachment 1 through 7 and 9 through 20. A yea vote is to grant the motion. A nay vote is to deny the motion. Please mark your ballots.
So when we're looking at the motion to dismiss the articles of impeachment, this particular motion deals with something called the prior term doctrine. Tony, talk to us about what that is.
Actually, essentially, that means that a person cannot be held responsible for information that the public knew prior to them being elected. So Ken Paxton, in this instance, has said that that claims against him were widely known prior to him being elected to a third term in November of last year, that they were the subject of campaign information, billboards across the state. And so, according to him, constitutionally, an impeachment charge could not be brought against him. But we also saw the House members and the House impeachment managers vigorously arguing against that, saying that during the course of their investigation, Ashley, they surfaced new information that the public did not know. And according to them, the public did not know that because they say Ken Paxton worked overtime to conceal that information from the public.
They also argue kind of against this idea of the prior term being related to his January term and saying that it's before office rather than before his last election. Let's listen to the vote now.
Clerk will pull at random and read the votes.
Johnson, nay. Springer, nay. Wertner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Zaffarini, nay. Blanco, nay. Lamantia, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, yay. Colcourse, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Eight yeas, 22 nays.
Members, please confirm your votes. Senator Alvarado?
Nay.
Senator Betancourt?
Yay.
Senator Birdwell?
Nay.
Senator Blanco? Senator Campbell?
Yay.
Senator Creighton?
Yay.
Senator Eckhart?
Nay.
Senator Flores?
Yay.
Senator Gutierrez?
Yay.
Senator Hall?
Yay.
Senator Hancock? Senator Hinojosa?
Yay.
Senator Huffman? Senator Hughes? Senator Johnson? Senator King?
Yay.
Senator Colcourse? Senator Lamantia? Senator Menendez? Senator Middleton? Senator Miles? Senator Nichols? Senator Parker?
Yay.
Senator Perry? Senator Swertner?
Yay.
Senator Sparks? Senator Springer?
Yay.
Senator West? Senator Whitmire? Senator Zaffarini? 8 yeas, 22 nays. The motion is denied. We are now taking up motion number 6, members, submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Quash Articles of Impeachment or Grant Request for Bill of Particulars. A yea vote is to grant the motion, a nay vote is to deny the motion. Mark your ballot.
And Ashley, as we watch this, so often we see members of the
please
Senate
collect the
vote
ballots.
along party lines, but in this particular instance, we are definitely seeing a departure from that.
And it's going to be interesting to remember those 8 yays. So those 8 senators who are continuing to vote yay on the notions. The prior 2 motions, we added 2 more senators to that list of 6. Those are Senator Charles Swertner from Georgetown, Senator Donna Campbell, who also represents Central Texas, Senator Tan Parker, Senator Bob Hall, Senator Charles Perry, Senator Lois Colcourse, Senator Paul Betancourt, and Senator Brandon Creighton. So if we're starting to see some lines drawn here, it's interesting to see where these 8 are ranking compared to the rest of their colleagues.
And the line is that many of these senators, most of these senators, are the harder right senators, the more conservative senators. And over the past several weeks, we have definitely seen Ken Paxton supporters essentially actually campaigning them to vote against this proceeding.
Ballots at random.
Let's listen in on this next vote.
Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwertner, nay. Campbell, yea. Nichols, nay. West, nay. Blanco, nay. La Mantilla, nay. Parker, yea. Hughes, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Perry, nay. Colcourse, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Zaffarini, nay. Six yeas, 24 nays.
To confirm the vote, Senator Alvarado, Senator Betancourt,
Yay.
Senator Birdwell,
Nay.
Senator Blanco, Senator Campbell,
Yay.
Senator Creighton,
Yay.
Senator Eckhart,
Nay.
Senator Flores,
Yay.
Senator Gutierrez,
Yay.
Senator Hall,
Yay.
Senator Hancock, Senator Hinojosa,
Yay.
Senator Huffman, Senator Hughes, Senator Johnson, Senator King,
Nay.
Senator Colcourse, Senator Lamantia, Senator Menendez,
Yay.
Senator Middleton,
Yay.
Senator Miles, Senator Nichols,
Yay.
Senator Parker,
Yay.
Senator Perry, Senator Schwertner,
Yay.
Senator Sparks,
Yay.
Senator Springer, Senator West, Senator Whitmire, Senator Zaffarini. There being 24 nay votes and 6 yea votes, the motion is denied. Members, now we are taking up motion 7, submitted by the respondent, Attorney General Paxton. The motion is entitled, Request for a Bill of Particulars. A yea vote is granting the motion. A nay vote is denying the motion.
We're doing 7.
Anybody else pick up the votes? All votes collected. All votes collected. Clerk will call the votes.
Campbell, yea. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yea. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Terry, nay. Colkhorst, yea. Betancourt, Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Zaffarini, nay. 6 yeas, 24 nays.
Members confirming the vote, Senator Alvarado? Senator Betancourt?
So as they're confirming the vote, we want to point out what exactly motion 7, this request for a bill of particulars, what that means. Tony?
And Ashley, this takes aim at the whole process that the House impeachment managers and investigators undertook during their effort over the spring and over the summer to draft these articles of impeachment. It really speaks to a broad scope that Ken Paxton and his attorneys have taken, Ashley, in terms of trying to get these articles of impeachment dismissed. We've seen them attack, as we pointed out, the prior term doctrine. We have seen them attack insufficient evidence. But now this article speaks to the actual process of the investigation.
Senator Perry?
And again, that motion denied. We'll go back and listen to the rest of this vote.
Senator West? Senator Whitmire?
Aye.
Senator Zaffarani? There being 24 nays and 6 ayes, the motion is denied. Oops, sorry. Members, now taking up motion 13 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 1. A yea vote is to grant the motion, a nay vote is to deny the motion.
So talking a little bit about this particular, the argument against motion 1 that they're asking to be again, it's dismissed in this particular case. It's that they argue the House's attempt to remove Attorney General Paxton due to his constitutional duties. He's basically arguing that he was not in violation of any law, that he was just carrying out his duties and doing some of these things.
They also, in these articles, Ashley, have pointed out that he was duly elected as the state's top attorney. That has been one of Ken Paxton's contentions all along as well. And according to him, this is an effort to undermine the will of Texas voters. So that also has been signature to his claims and his efforts to try to get these cases dismissed. Really, it's been a full throttle approach.
And Article 1 is an article of disregard of official duty. That's the title of the article. The argument is that he failed to act as a public protector of the charitable organizations whenever the Attorney General's office got involved in a lawsuit between the nonprofit group, the Mitt Foundation, and Nate Paul. Let's listen to the vote on this one.
Birdwell, nay. Hall, yea. Perry, yea. Colcourse, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yea. Hughes, nay. Hancock, nay. Menendez, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, yea. Campbell, yea. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Eight yeas, 22 nays.
So as the Lieutenant Governor is verifying this vote, again, this was the motion to dismiss Article 1. The Attorney General argues that he had a duty to intervene in this lawsuit between, real estate developer Nate Paul and the foundation.
Senator Hall.
And Ashley, that has been one of the signature issues in this case, is the degree to which Ken Paxton acted on behalf of Nate Paul, who, as you mentioned, was engaged in that lawsuit. The Attorney General's office generally is designed and supposed to act on behalf of nonprofits. In other words, act in their interest. And the reason his actions, his alleged actions in the Midday Foundation lawsuit turned heads, Ashley, among whistleblowers in his office, is that he seemed to be taking action adverse to the Midday Foundation.
Members, you have 9 more to vote on.
We have 9 more motions. Let's listen into the next one.
Members, we're taking up motion 14 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 2.
So Article 2 is another article, accusing the Attorney General of disregard of his official duty. This one argues that he misused his official
pick up the
power
motions.
to write a legal opinion, and that opinion was an effort to try to stop a foreclosure sale of properties owned by Nate Paul, and that the Attorney General had his employees reverse their legal conclusion?
Well, exactly, Ashley. And what is so important about this particular article is that the Attorney General is accused of seeking an opinion related to the sale of foreclosures, seeking it from one of the senators, Brian Hughes, who is now one of the jurors in his case. So the allegation is that Ken Paxton went to Senator Hughes and said, hey, I need you to request an opinion of my office concerning foreclosure sales.
And that was after the opinion had already been, according to the House managers, after the opinion had already been issued during the COVID pandemic. We're going to listen to the vote on this now.
Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, yay. Fullcourse, yay. Betancourt, yay. Brayton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Wartner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Eight yeas, 22 nays.
Confirming the vote, Senator Alvarado. Senator Betancourt.
And Ashley, I just want to describe this article a little bit clearer for folks. So Ken Paxton is accused of taking multiple steps to help Nate Paul. Nate Paul's property was the subject of a foreclosure sale. And so this speaks to the heart of the allegations of Ken Paxton using and abusing his office in the protection of Nate Paul. In other words, in this instance, drafting a legal opinion allegedly to stop a foreclosure sale during the pandemic, property of which Nate Paul was set to be sold.
That's right. We'll listen back in as they're wrapping up this vote.
There being 22 nay votes, 8 yea votes, the motion is denied. Members, we are now taking up motion 15 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 3. A yea vote is to grant the motion, a nay vote is to deny the motion.
So when we look at what Article 3 is, this is another article titled Disregard of Official Duty, accusing Paxton of abusing the open records process. The House managers argue that he misused his power to administer the public information law by directing his office to refuse to give a decision for a request for a DPS record.
And Ashley, this speaks to records that allegedly Nate Paul, who was under investigation himself by the FBI, that he was trying to get records as part of the investigation into him. And so the allegation then is that he solicited Ken Paxton to try to get records so that he could learn what the feds were going after him about.
And it's very interesting. I think the thing that we're all watching and sort of waiting to hear is why Attorney General Paxton went to the lengths that he is accused of going to for Nate Paul.
Well, and the allegations are two-pronged that we know of at this point.
Right.
Two reasons. There is the allegation of that home remodel of Ken Paxton's home here in Austin and the Terrytown neighborhood. And then the second alleged reason, Ashley, was employment by Nate Paul of Ken Paxton's mistress, a former Capitol staffer with whom he is said to have had an affair.
That certainly is what the House managers say Paxton was getting out of all of this. Let's listen in on the vote for Article 3.
We'll call out the vote.
Parker, yay. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Blanco, nay. La Mantilla, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Perry, nay. Colcourse, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. Ing, nay. Sparks, nay. Flores, nay. Seven yeas, 23 nays.
Confirming the vote, Senator Alvarado,
Nay.
Senator Betancourt,
As they are confirming this vote again, Article 3 accuses Paxton of misusing the public information law to help Nate
Senator
Paul.
Flores, Senator Gutierrez.
And Ashley, typically speaking, a person cannot obtain information during an ongoing criminal investigation. In other words, we as journalists typically are rejected when we try to submit a request for information during the course of an investigation. But again, this article accuses Paxton of taking steps to try to get information, obtain information related to the law enforcement investigation of Nate Paul, which, by the way, Ashley, did result in multiple federal charges against Nate Paul earlier this summer on a number of financial crimes.
Let's listen in on the next motion.
Members, we're now taking up motion 16 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 4. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballot.
Article 4 also is under disregard of official duty. This article alleges that General Paxton misused his power to, again, administer public information law, and they said that he improperly obtained private information that should not have been public, and shared it with Nate Paul, again, to help him find out more about
Please
that
pick up the
federal
ballots.
investigation.
And actually, the underpinning of all of this is that Nate Paul allegedly went to Ken Paxton and said, I believe I am being wrongly targeted by federal investigators. I believe they have acted unprofessionally, not just unprofessionally, but illegally in terms of their search of my property in 2019. So what Nate Paul, according to whistleblowers, did was actually concoct this story about the fact that the allegation that federal investigators, tampered with the search warrant to his house. In other words, they searched his property and then went back and amended the search warrant and tampered with it in an illegal way. So that was the underpinning of his claim that he took to Ken Paxton and said, Mr. Attorney General, I need your help. By that time, Ashley, we know that they had something of a relationship. We don't know the exact nature of the relationship at that time, though.
And one of the things we also know, Ken Paxton himself under federal investigation.
Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Berry, nay. Colkhorst, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yea. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Wartner, nay. Campbell, yea. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Six yeas, 24 nays.
Confirming the vote, Senator Alvarado. Senator Betancourt.
If you're just joining us, this is KVUE News special coverage of the impeachment trial of suspended Texas Attorney General Ken Paxton. Myself, Ashley Godot, and KVUE senior reporter Tony Plahetsky are bringing you live coverage and analysis of this historic trial as it's happening.
Historic indeed, Ashley. Only one time over the past century has a statewide elected official faced impeachment. And so that is why we are devoting our airwaves and our time and effort today to bring this to you at home. It is, in fact, an instance in which many of the nation's eyes are on the Texas Capitol as this unfolds. It is a fact-finding trial, a fact-revealing trial, but Ashley, Lieutenant Governor Dan Patrick has also said that this is a political trial, and that is why so many of us are watching.
Attorney General Paxton, the motion is entitled Motion to Dismiss Article 5. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballots.
What's happening right now is they are voting on all of the pretrial motions that were filed ahead of the trial. And so when they take these votes, again, if you're just now joining us, the article is read. There are no arguments, no discussion of what the articles are, and the lawmakers submit their vote in writing. The Secretary of the Senate, Patsy Spall, reads that, and then the Lieutenant Governor confirms it with a voice vote. Article 5 is a disregard of official duty. It is accusing the Attorney General of having an associate of Nate Paul hired by the Attorney General's office and then having him investigate what the House Managers calls a baseless complaint on Nate Paul.
And Ashley, this was so striking because Ken Paxton's staff, his top brass, said to him, "We do not believe, Mr. Attorney General, that you should be engaging in this at all with Nate Paul." And so they claim that unbeknownst to them, Ken Paxton then hired a special prosecutor, an attorney who had no prosecutor experience from Houston, had only in fact been out of law school for a few years. And so that was especially baffling to Ken Paxton's top brass.
Flores,
Let's
nay.
listen to this next vote.
Johnson, nay. Springer, nay. Schwartner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Blanco, nay. Lamantia, nay. Parker, yay. Hughes, yay. Miles, nay. Gutierrez, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Perry, nay. Colkhorst, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, nay. Eight yeas, 22 nays.
Confirming your vote, Senator Alvarado. Senator Betancourt.
Hey.
Senator Birdwell.
Hey.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Hey.
Senator Eckhart.
Nay.
Senator Flores.
Hey.
Senator Gutierrez.
Nay.
Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Hey.
Senator Huffman.
Hey.
Senator Hughes.
Yay.
Senator Johnson. Senator King.
Nay.
Senator Colkhorst. Senator Lamantia. Senator Menendez. Senator Middleton. Senator Miles.
Hey.
Senator Nichols. Senator Parker. Senator Perry. Senator Schwertner.
Hey.
Senator Sparks.
Hey.
Senator Springer.
Hey.
Senator West.
Hey.
Senator Whitmire.
Hey.
Senator Zaffarini. 22 nays, 8 yeas. The motion is denied. Members now taking up motion 17 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 6. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your voting form.
Article 6, again, you're hearing this title over and over again, but Article 6 is
motion
disregard
17,
of official
Motion
duty.
17.
And this one deals with Attorney General Ken Paxton's decision to fire
let me
the
know.
whistleblowers who reported him to federal
If you cannot
authorities.
hear clearly, let me know.
And Ashley, not only did that termination trigger this impeachment article, it also triggered a whistleblower lawsuit against Ken Paxton. And people who have been following this story know that in February, it was that tentative settlement for $3.3 million to settle with those whistleblowers. that triggered all of this.
That is why we are here
That's
today.
exactly
In fact, the
right.
House managers wrote it. They said it out loud. Had he not asked the state to pay out that whistleblower settlement, we would not be where we are right now.
Taxpayer money for his alleged wrongdoing.
And we should point out, though, those whistleblowers have a complaint with the Attorney General's Office of Texas. That is his argument, is that they were not suing Ken Paxton, but rather the Attorney General's office. This is his argument, and that is why they felt the Attorney General's office should be the ones to pay out the settlement.
And under state law here in Texas, whistleblowers must bring a claim against a state agency and not an individual office holder.
Read the vote.
Perry, yay. Colkhorst, yay. Bettencourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, yay. Flores, nay. Blanco, nay. La Mantilla, nay. Parker, yay. Hughes, nay. Miles, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, yay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Nine yeas, 21 nays.
Confirming your vote, Senator Alvarado.
Yay.
Senator Bettencourt.
Yay.
Birdwell.
Yay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores.
Yay.
Senator Gutierrez. Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman.
Yay.
Senator Hughes.
Yay.
Senator Johnson. Senator King.
Yay.
Senator Colkhorst. Senator La Mantilla.
Nay.
Senator Menendez.
Yay.
Senator Middleton. Senator Miles. Senator Nichols.
Yay.
Senator Parker.
Yay.
Senator Perry. Senator Schwartner.
Yay.
Senator Sparks.
Yay.
Senator Springer.
Yay.
Senator West.
Yay.
Senator Whitmire.
Yay.
Senator Zaffarini. 21 nay votes, 9 yea votes. The motion is denied. We're now taking up motion 18 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Article 8, excuse me. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballot.
Now, this article, Article 8, is also related to something that Tony and I spoke to earlier, and it's dealing with the settlement agreement. So this article claims that Attorney General Paxton entered into that settlement agreement with whistleblowers and concealed his wrongful acts, and that he deprived voters of the opportunity to make an informed decision, the House managers say, by entering that agreement rather than letting it play out in trial.
And Ashley, just going back in time a little bit for people who are maybe just now coming into this story, those whistleblowers told Ken Paxton at the end of September 2020 during the pandemic that they were going to federal officials, that they believed that he was violating the law.
I have my 8 motions, which will not take as long to announce, and then we'll take a break at that point.
So just a scheduling note as a Lieutenant Governor, as the votes are being...
After that point, we will come back and begin the trial.
As the votes are being collected there, that they're going to wrap up his motions, take a break before opening statements. But it looks like they're getting ready to announce this vote now.
Well, ballots in, thank you. Clerk will read the votes.
Hancock, nay. Menendez, nay. Birdwell, yay. Hall, yay. Harry, yay. Oakhorst, yay. Betancourt, yay. Creighton, yay. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, yay. Flores, nay. Blanco, nay. Lamantia, nay. Parker, yay. Hughes, yay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, nay. Campbell, yay. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Ten yeas, 20 nays.
Confirming the vote. Senator Alvarado?
Nay.
Senator Betancourt? Senator Birdwell?
Yay.
Senator Blanco? Senator Campbell?
Yay.
Senator Creighton?
Yay.
Senator Eckhart? Senator Flores?
Yay.
Senator Gutierrez?
Yay.
Senator Hall?
Yay.
Senator Hancock? Senator Hinojosa?
Yay.
Senator Huffman? Senator Hughes? Senator Johnson? Senator King?
Yay.
Senator Colcourse?
No.
Senator Lamantia?
Nay.
Senator Menendez? Senator Middleton? Senator Miles? Senator Nichols?
Yay.
Senator Parker?
Yay.
Senator Perry? Senator Schwertner? Senator Sparks?
Yay.
Senator Springer?
Yay.
Senator West?
Yay.
Senator Whitmire?
Yay.
Senator Zaffarini?
Nay.
There being 20 nays and 10 yays, the motion is denied. We are now taking up motion 19, submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Dismiss Articles 7 and 15. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballots.
So Ashley, just to put this in a broader perspective, this impeachment proceeding is not off to a good start for Ken Paxton. He had hoped to defeat these impeachment articles, prevent a trial from going forward, but that is clearly not where the senators are this morning.
Right, and I think it's interesting to listen to these votes and how senators are voting, particularly as we see there are 6 senators that are solidly with Ken Paxton. They're voting every time to dismiss, they're voting every time to quash. And then there are about 3 others that are swinging back and forth, and to show that they have not quite made their minds up yet about this.
And here in our viewing area, one of those senators is Senator Charles Schwartner from Georgetown, whose vote seemed to be, who seems to be voting differently on some of these efforts to overturn these impeachment articles.
Meanwhile, Senator Campbell, also from our area,
yes,
solidly wanting to grant these motions. Let's listen to this next vote.
Senator Blanco, no. Senator LaMantia, no. Senator Parker, yay. Senator Hughes, nay. Senator Miles, nay. Senator Gutierrez, nay. Senator Johnson, nay. Senator Springer, nay. Senator Schwartner, yay. Senator Campbell, yay. Senator Nichols, nay. Senator West, nay. Senator Whitmire, nay. Senator Huffman, nay. Senator Hinojosa, nay. Senator Zaffarini, nay. Senator Hancock, nay. Senator Menendez, nay. Senator Birdwell, nay. Senator Hall, yay. Senator Perry, yay. Senator Colcourse, yay. Senator Betancourt, yay. Senator Creighton, yay. Senator Middleton, nay. Senator Alvarado, nay. Senator Eckhart, nay. Senator King, nay. Senator Sparks, yay. Senator Flores, nay. Nine yeas, 21 nays.
Confirming the vote, Senator Alvarado. Senator Betancourt.
Yay.
Senator Birdwell.
Yay.
Senator Blanco.
Yay.
Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores.
Yay.
Senator Gutierrez. Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman. Senator Hughes. Senator Johnson. Senator King.
Yay.
Senator Colcourse. Senator LaMantia. Senator Menendez. Senator Middleton. Senator Miles. Senator Nichols.
Yay.
Senator Parker.
Yay.
Senator Perry.
Yay.
Senator Schwartner.
Yay.
Senator Sparks.
Yay.
Senator Springer. Senator West. Senator Whitmire.
Yay.
Senator Zaffarini. There being 21 nays, 9 yeas, the motion is denied. We're now taking up motion 20, submitted by the respondent, Attorney General Paxton. The motion is entitled, Motion to Dismiss Articles 9 and 10. A yea vote is a grant the motion, a nay vote is to deny the motion. Please mark your vote on your voting form.
Now, Articles 9 and 10 allege that Attorney General Paxton engaged in constitutional bribery. If you've been with us since we've been covering this morning, Tony has talked about what the Attorney General allegedly received in exchange for helping real estate developer Nate Paul. Run us through that again, Tony.
Yeah, Ashley, it all goes back to allegations that he received a home remodel. He has a house, the Paxtons have a house in Terrytown on Margranita Crescent. It's public record, public information. It has been named in filings. And this came, Ashley, interestingly enough, this allegation actually came from a young man, an SMU graduate, who had the role of a Paxton aide. In politics, they're often called body men. In other words, a top aide who travels with an elected official. And in this instance, his name is Drew Wicker. Again, his name has been made public. He is alleged to have overheard a conversation that made him believe that Nate Paul was paying for this home remodel. And so that really caused a lot of concern within the AG's office, Ashley.
Yeah, that kitchen remodel. The second article relates to Nate Paul allegedly hiring the woman whom Paxton is accused of having an extramarital affair with. Let's listen to the vote on these motions to dismiss these articles.
King, nay. Sparks, nay. Flores, nay. Blanco, nay. Lamantia, nay. Parker, yea. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Schwartner, nay. Campbell, yea. Nichols, nay. West, nay. Whitmer, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Perry, nay. Colcourse, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. Six yeas, 24 nays.
Confirming the vote, Senator Alvarado,
Yay.
Senator Betancourt,
Yay.
Senator Birdwell,
Yay.
Senator Blanco,
Yay.
Senator Campbell,
Yay.
Senator Creighton,
Yay.
Senator Eckhart,
Yay.
Senator Flores, Senator Gutierrez, Senator Hall,
Yay.
Senator Hancock, Senator Hinojosa,
Yay.
Senator Huffman, Senator Hughes,
Yay.
Senator Johnson, Senator King,
Nay.
Senator Colcourse, Senator Lamantia, Senator Menendez, Senator Middleton, Senator Miles, Senator Nichols.
Nay.
Senator Parker.
Yay.
Senator Perry. Senator Perry. Senator Perry. Nay, we can't hear you. So, Senator Swartner. Senator Sparks.
Nay.
Senator Springer.
Nay.
Senator West.
Nay.
Senator Whitmire. Senator Zaffarini. 24 nay votes, 6 yea votes. The motion is denied. We're now taking up motion 21, submitted by the respondent. Attorney General Paxton. The motion is entitled Motion to Dismiss or Hold in Abeyance Articles 16 through 20. A yea vote is to grant the motion, a nay vote is to deny the motion. Please mark your ballot.
And Ashley, we are nearing the end of these multiple pretrial motions. Again, this was the effort that Ken Paxton was taking really from a number of different perspectives to try to have this trial halted on its very first day without it going forward.
Right, a simple majority vote of the Senate is what would be needed to grant any of these motions to dismiss. So that would have been 16 of the senators who are sitting on the jury. And we're not seeing it even come close. We've not even seen a close vote on any of these motions. Again, there are 16 of these motions. There are 8 other motions that the lieutenant governor, who is serving as the presiding officer, will rule on. But these, any motion that would result in the dismissal of an article, had to be voted on by the body.
There are other motions that, again, the lieutenant governor will take up, but those motions deal, for example, with an effort by Paxton to eliminate some of the jurors in this case. He targeted several Democrat senators who he said made public statements, Ashley, that they should not have made, and that, in his mind, showed their bias against him and that they could not be fair jurors.
And also the witness list, and whether or not Ken Paxton himself will have to take the stand. Still some really big motions that the lieutenant governor is going to get to, weigh in on.
But I think as we near 11 o'clock, we're 2 hours into this. I think it is abundantly clear that we are going to have a trial.
Indeed we are. That is crystal clear at this point. Let's listen in on the vote.
Members, you have one more motion after this to rule on, and then I will rule on my 8 pretrial motions. Yes. Pardon? Senator West, do you want to approach the bench or the clerk? You may come up.
Find it. Oh,
You may read the votes.
okay. Colkhorst, yay. Johnson, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Perry, yea. Springer, nay. West, nay. Wertner, yea. Campbell, yea. Nichols, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Betancourt, yea. Brayton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. King, nay. Sparks, yea. Flores, nay. Blanco, nay. Lamantia, nay. Parker, yea. Hughes, nay. Miles, nay. Gutierrez, nay. Nine yeas, 21 nays.
Confirming the vote, Senator Alvarado.
Yay.
Senator Birdwell. Senator Birdwell, go ahead. I called you.
Yay.
Senator Betancourt.
Yay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores.
Yay.
Senator Gutierrez. Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman. Senator Hughes. Senator Johnson. Senator King.
Yay.
Senator Colcourse.
Yay.
Senator Lamantia.
Nay.
Senator Menendez.
Yay.
Senator Middleton. Senator Miles.
Yay.
Senator Nichols.
Yay.
Senator Parker.
Yay.
Senator Perry. Senator Swertner.
Yay.
Senator Sparks.
Yay.
Senator Springer. Senator West. Senator Whitmire.
Yay.
Senator Zaffarini. 21 nays, 9 yeas. The motion is denied. Members, this is your last motion to take up. This is motion number 10, submitted by the respondent, Attorney General Paxton. The motion is entitled, Motion to Exclude Evidence Gathered in Violation of the Law. A yea vote is to grant the motion. A nay vote is to deny the motion. Please mark your ballot. Please pick up the ballots. All ballots collected. The clerk will call out the votes.
King, nay. Sparks, yea. Flores, nay. Blanco, nay. Lamantia, nay. Parker, yea. Hughes, nay. Miles, nay. Gutierrez, nay. Johnson, nay. Springer, nay. Fortner, yea. Campbell, yea. Nichols, nay. West, nay. Whitmire, nay. Huffman, nay. Hinojosa, nay. Zaffarini, nay. Hancock, nay. Menendez, nay. Birdwell, nay. Hall, yea. Perry, nay. Colcourse, yea. Betancourt, yea. Creighton, yea. Middleton, nay. Alvarado, nay. Eckhart, nay. Eight yeas, 22 nays.
Confirming the vote, Senator Alvarado. Senator Betancourt.
Yay.
Senator Birdwell.
Nay.
Senator Blanco. Senator Campbell.
Yay.
Senator Creighton.
Yay.
Senator Eckhart. Senator Flores. Senator Gutierrez.
Yay.
Senator Hall.
Yay.
Senator Hancock. Senator Hinojosa.
Yay.
Senator Huffman. Senator Hughes.
Yay.
Senator Johnson. Senator King.
Yay.
Senator Colcourse. Senator Lamantia. Senator Menendez. Senator Middleton. Senator Miles. Senator Nichols. Senator Parker.
Yay.
Senator Nichols was nay. I didn't mean to speak over you. Senator Perry. Senator Swartner.
Yay.
Senator Sparks.
Yay.
Senator Springer.
Yay.
Senator West.
Yay.
Senator Whitmire.
Yay.
Senator Zaffarini. Being 22 nays and 8 yeas, the motion is denied. Members and those in the gallery and watching, the senators voted on the rules 25-3, and part of those rules say that all other pretrial motions shall be ruled on by the presiding officer, which is myself. I'll begin with motion 2, submitted by the House Board of Managers. This motion is entitled Motion to Clarify Certain Senate Rules Governing the Impeachment Trial of Warren Kenneth Paxton Jr. This motion was partially addressed by my August 9th exhibit production order. Additionally, the manager's request for clarification on timing has been addressed through an agreement of the parties last week. For those watching, I'll clarify the timekeeping for the trial moving forward. There has been much discussion on the impeachment rule, especially number 17 on time limitations. Each side of the House managers and the Attorney General Paxton has 1 hour for opening statements, 24 hours for presentation of evidence, 1 hour for rebuttal evidence, and 1 hour for final arguments. 7 hours for each side. Both parties, the managers and Attorney General Paxton are in agreement on this issue, which pleases the court. Managers, in this motion, you state, at a minimum, you seek clarification that the time spent by an opposing party on cross-examination will be counted only against the party conducting the cross-examination. Attorney General Paxton's team, you responded that time spent questioning a witness, whether via direct or cross-examination, is charged against the side conducting the questioning. Based on your agreement of last week, this is how the clock will run. For example, House managers, when you call a witness, any direct questioning of the witness counts against your 24 hours. When Paxton's team questions the witness on cross, time will be counted against your clock. I also want to note that the clock will keep running through routine objections. However, if I find that it's being abused by either side, I can always use my discretion to give back the time to the other party. To summarize, so we're clear, what everyone has agreed to, both parties have a total of 24 hours for presentation of evidence, which includes direct, cross-examination, redirect, and recross. Anytime a party questions a witness, whether via direct, cross, redirect, recross, the clock will continue to run. And again, in addition to the 24 hours, each party has 1 hour for opening statements, if they choose to make those, 1 hour for rebuttal, and 1 hour for closing arguments. I've also told both sides, if they do not use the full hour allotted for their opening statement, any remaining time will be added to their 24 hours for presentation of evidence. For example, if one side only uses 30 minutes, they will have 24 and a half hours of time. Finally, managers requested to change the rules regarding the use of wireless mobile devices. A rule change must be submitted in writing during trial and requires a 24-hour layout period. Accordingly, this motion has been addressed and no further action shall be taken. Now I will take up motion 24 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Compel Discovery from House Managers. This motion was addressed by my July 12th discovery order and August 9th exhibit production order. Therefore, no further action on this motion will be taken. Now I'll take up motion 12 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Exclude Inadmissible Evidence. This addresses the issue of political contributions. Because this information is readily available from the Texas Ethics Commission for everyone to read, this motion is denied. Now I will take up motion 23 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion for Notice of Brady Material and Notice of Trial Exhibits. The motion was addressed by my July 12th discovery order and August 9th exhibit production order. Accordingly, no further action is needed on this motion. Now we'll take up motion 3 submitted by the House Board of Managers. The motion is entitled Request to Clarify the July 12th discovery order, or alternatively, motion for protective order regarding documents produced to Warren Kenneth Paxton Jr. pursuant to the Senate July 12th discovery order. This motion was addressed by my July 20th reiteration of the orders of the court. Accordingly, no further action on this motion. Now I will take up motion 1 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion for Pretrial Scheduling Order or Pretrial Conference. This motion was addressed by my July 12th discovery order and August 9th exhibit production order. Accordingly, no further action is needed. Now I will take up motion 4 submitted by the respondent, Attorney General Paxton. The motion is entitled Motion to Preclude Attorney General Warren Kenneth Paxton Jr. from being compelled to testify. This court notes that many factors and circumstances in this proceeding lean more on criminal in nature. The rules require a standard of beyond a reasonable doubt, which is reserved for criminal cases. Exculpatory evidence was required to be produced consistent with criminal cases. The rules require a plea to the court to be guilty or not guilty, which are the pleas exclusively used in criminal cases. Judgments of the court of impeachment are entered as acquittal or conviction. which are operative terms for judgments in criminal cases. And the House of Managers have repeatedly compared the actions of the House of Representatives to a grand jury, as they prefer the articles of impeachment. Grand juries are utilized only in criminal cases. Therefore, the motion is granted. The Attorney General cannot be compelled to testify. This is consistent with the reasoning and judgment in the United States Supreme Court, Boyd versus the United States. The court's ruling is clear. You may not call the Attorney General as a witness. Finally, I would take up motion 5 by Respondent Attorney General Paxton. The motion is entitled Motion Challenging Jurors for Cause. That motion is denied.